Good evening and welcome to 42BR Barristers. We are having our second Financial Remedies webinar in our series tonight. For information, if you'd like to see any of the other private, public, or indeed the first Family Remedies webinar, these can be found on the 42BR website or our YouTube channel. I'm going to be speaking tonight along with Jeremy. We're going to be covering TOLATA. We're also going to be covering proprietary estoppel. I'm going to begin with that. There will be an opportunity possibly for questions, although we think we're going to be tight on time tonight. If you'd like to ask some questions, if you could please use the Q&A box, and these will be addressed either at the end of the session, time permitting, or indeed we will follow up any questions via email. Lastly, there will be an email containing the recording with slides and a feedback form, and that will be circulated over the next few days. And the recording of this seminar will be available on our website and YouTube channel in the usual way. So I'm going to start tonight with the topic of proprietary estoppel. We obviously had a Supreme Court decision in Guest and Guest. And it's interesting to have a look at the cases that have arisen subsequently. I don't think that I'm going to be discussing tonight anything terribly new in terms of groundbreaking legal development or elucidation of Guest and Guest. I'm only going to discuss a couple of cases, but we will go into those in detail and go into them because I think they're useful generally in terms of the approach that we use in these types of case. And the facts are always illuminating, and no doubt there will always be some overlap between the sort of cases that come across our desks and cases that appear in the case law. To start with, I'm going to just do a very brief overview of the principles of proprietary estoppel. Some of the principles that I'm going to discuss now will come up in the couple of cases that I'm going to review. Not all of them, and you'll obviously be very familiar with them. But nevertheless, for the purposes of the slides, it's quite useful to have the fundamental principles there. And I've set some of those out, hopefully comprehensively, in the next few pages. You'll all, to start with, be aware that there are a number of key components in proprietary estoppel, and you'll be very familiar with the fact that you need an assurance. You need the person who is seeking to put forward the estoppel has got to establish that they've relied on an assurance, and they have to have relied on it to their detriment. And those are three really of the cornerstones. But the topic goes wider than that, because there is the fundamental principle of unconscionability, which underlies the whole topic. And lastly, there's always the potentially difficult question of the remedy that the court is going to give if the person alleging the estoppel is able to make it out. So I start with the first principle, first of those components, which is assurance. And I've just set out three extracts from case law, which are, again, they're useful to go back. They're useful to go back to. I think these quotes were all mentioned by way of reference to the law in the two cases that I discuss, and more or less, they are therefore sort of fundamental touchstone expressions of what you'll be looking for when you're considering an estoppel. To start with, an assurance must be clear enough, and the key question here is how much clarity do you need? And in Thorner and Major, which you see there that's in UK Houses Lords 18, that is hugely dependent upon context. I won't say very much more about that. Suffice to say that obviously this principle of context is everything, and I think that's as relevant in life generally as it is in law. And it is not invariably the case that you have to, if you're acting for a client, you have to extract specific remembered words in relation to any assurance which the client is seeking to rely on. The general recollection, as long as it is sufficiently clear, will suffice. Secondly, the assurance must be that your client was going to acquire a property interest in specified property. That is fairly critical. Proprietary estoppel, the clue is in the name, and it concerns specifically property. And therefore, there needs to be specific discussion, a specific promise, assurance, some form of encouragement in relation to an identifiable piece of property. The idea that the discussion concerns perhaps a job or a role or other responsibilities is not going to be enough in relation to proprietary estoppel. Lastly, the assurance does not need to be expressed in an irrevocable way. In other words, people can bring forward assurances which were made and talked about in a context where, in fact, the person who was making those assurances may perfectly properly have intended or have thought of the assurances as revocable. In other words, something that they could at a later date take back. And this, of course, it might seem a little bit surprising, the idea that a legal principle can be based upon a statement or a promise which intrinsically might be taken back or might be resiled on by the maker of it. Might seem a little bit odd. But when you think of the sorts of situation of which proprietary estoppel is now regularly being applied, and in particular, I'm thinking about cases where a person does something and expects to receive an inheritance in a will, that, of course, is a classic case of a situation, and given that wills are well known to be revocable documents, people are entitled to change their will, and they do change their will very often over a period of years, and their intentions change naturally as they get older. Nevertheless, intentions made about property that is going to be left to someone in a will, albeit that is obviously a revocable statement, that is something nevertheless upon which your client may be able to base an estoppel argument. We're talking here, also going a little bit further, we're talking here about a distinction between statements of present intentions, which are at the point they're made intended clearly revocable, as opposed to the sort of statement which is, notwithstanding that it's revocable, is closer to a promise. It's that sort of assurance, albeit revocable, but closer to a promise. That's the sort of assurance that you're looking for, and on which your client will be able to found detrimental reliance. So that's assurance. There's the next principle, or the next part of proprietary estoppel chain, or the linked system, is the principle of reliance. I'm not going to say very much about that. It'll be well known that you have to show that there is a sufficient link between the assurance and the conduct which constitutes the detriment. The communication or the statement made by the assurer does not have to be the sole inducement. It is sufficient that it is an inducement. This is something sometimes described as you have to show that there is a material inducement, something significant that causes you to act in a certain way. Thirdly, you have the principle of detriment. And I'm just going to, I've taken a quote there from one of the cases I'm going to discuss. Reliance and detriment are often intertwined, and that's undoubtedly correct. And they're sometimes referred to together as detrimental reliance. And it's important, but nevertheless important to keep one's mind on the two things. The reliance is the linkage, but the detriment is the actual loss or the actual change of position engaged in or suffered by your client. And those two things are slightly different. Note that if you're in litigation, detriment is a very important issue, and indeed must be formally pleaded and proved. And that's something that should be at the forefront of your mind when taking instructions from the client. It is the touchstone and entry point through which the estoppel argument inevitably is going to pass. The fourth quality that has to be established in relation to a proprietary estoppel is unconscionability. Essentially, once the detriment is established, the broad inquiry that then arises is whether the repudiation of the assurance is or is not unconscionable. And you'll see I put a large quote there from Robert Walker, Lord Justice in Gillett. I'm not going to go through that. Suffice to say that fundamentally, this is a document generated by equity, and the fundamental principle of equity is about trying to attach to people's consciences, and unconscionability is the factor that runs through all of the elements of proprietary estoppel: assurance, reliance, detriment, and indeed also in relation to remedies. And lastly, there is this quite distinct topic of remedy. If the equity has arisen, the court must decide how that equity is to be satisfied and what remedy to give. The phrase that used to float around, one certainly that I used to write frequently in advices, is what one's looking for is what is the minimum equity to do justice between the parties. And there is to some extent what there was originally, and many years ago, a temptation in my mind to think of the minimum equity as focusing on what the client has lost. In other words, the detriment the client has suffered. That is really not the emphasis in today's climate. The emphasis here is on the minimum equity to do justice to the parties. And in Guest and Guest, of course, the very important recent Supreme Court case on this, the court made it very clear that really the court is focused, when providing a remedy, on satisfying the expectation of the relevant person bringing forward the estoppel. So it's not about simply compensating for any loss or for any detriment suffered. It's primarily, or it's a starting point, is an expectation based approach. So having gone through that run through, I'm going to take this quite quickly. I'm not going to go through the full section, but I've set out some of the quotes. I think are the relevant quotes from Guest. They're there for you in relation to the right approach to remedy, because I think we need to get on to the facts of Spencer and Spencer itself. That's the first of the cases. I'm going to discuss two cases, Spencer and Spencer. This is if I can put it this way, is a death time case. As I said earlier on, it's about a family where the father of the family made promises to a son in the family, saying that property would be left in his will to the son. And of course, it's a case scenario that you'll be very familiar with. This sort of situation has started creeping into the case law for about 20, 30 years. It was originally treated with great skepticism that you could have proprietary estoppel in a situation like this. But it's completely standard now and well recognized that this is appropriate for a proprietary estoppel. The other case I'm going to discuss is Teasdale versus Carter. In a minute, that's more typically a lifetime case. This is a scenario where essentially, again, someone believes they own property. And during their life, the relevant property owners seek to resile from the apparent or the alleged promise. But I'll start with Spencer and Spencer. Incidentally, they're both farming cases, and of course, Guest and Guest itself also involved a farm. And these cases, which involve a high degree of family-type business relationships, dynastic handing on of property, which has this tendency to involve people committing their lives to the farm business. This throws common. It's very common for this type of problem to be thrown up, obviously, in those type of cases. So I put the facts down there on the slide there. The claimant was the son, and he claimed his late father had promised that he would inherit the freehold land comprising the farm on his father's death. It's about 405 acres of land. And the father died in October 2018. Note that date. And the father's will, the first will made in 2003, had left the land to the claimant. So on the face of it, we've got a classic scenario: son working the farming business. Father says, if you work in the business, all this will be yours, my son. And indeed, the will that had been made by the father mirrored that precisely. However, and this obviously a however, a new will was made by the father in March 2018, and that under that will, the land was left to the trustees, family trustees on discretionary trusts for all of the father's children. That is including the son and the grandchildren. The reason for that was that lately the son had contracted multiple sclerosis. And for that reason, the father had changed his mind a little bit about the way in which the property might devolve. So he was a bit concerned about that, although that was perhaps less important in the case. What was most fundamentally important was that the son had believed that the whole of the land was going to go to him. So, as I say, there are no earth-shattering legal applications in this case. I think what's very interesting is to read it just simply for the profile of the dispute, and in particular the profile of the evidence that was collected and the way in which that evidence impacted in the decision in the case. As far as the assurance was concerned, very interesting reading the judgment. There are a number of conversations alleged, often only between the father and the son, who had a tempestuous relationship, and indeed the very general statements that had been made in relation to the son inheriting the business if he worked hard. Oh, I beg your pardon. The son inheriting the land if he worked hard for the farming business and in relation to the land. Those general statements were made during arguments, which is, again, perhaps it's almost a little counterintuitive, but one can almost see it as well, that when arguments arose and tensions arose, that the matter was the relationship was restabilized by a promise effectively of this sort. Fundamentally, the judge decided that even though the claimant's evidence was rather unreliable, and apparently he made a very terse witness, just simply saying yes to frequent questions, he was fundamentally honest. And for that reason, he succeeded in the case. One interesting point that I put there on this particular slide is the question of his credibility. And when he first came forward with his claim that his father had made the relevant assurance, the will that his father, the second will that his father made was in 2018. And it was only in 2019, after it had become apparent what the will said, and after the claimant had gone to a second meeting with the family solicitor, it was only then that he said his father had made these assurances. And one can see the obvious point here, that the longer it takes any potential claimant to effectively allege that the assurances were made, the longer it takes that claimant to come out with their claim effectively, the greater the potential lack of credibility. The judge dealt with it, though, in a very interesting way. I'm just going to read out what the judge said in the judgment of paragraph 68. He said, "Until advised about the nature of a proprietary estoppel claim, few lay people would think that there might be a remedy available at law for a son who's been foolish enough to rely on oral assurances made by his father. A son faced with the soul-destroying, gut-wrenching realization of being deprived," that's a quote from Guest, "for which he thinks he has no remedy and only himself to blame, can react in a number of different ways, and embarrassed silence is one of them." Now, I think that quote may well see the light of day in subsequent cases, because, of course, it's the judge accepting that even though the son did not come forward immediately, as far as he was concerned, he accepted that there was a good reason for that. Moving on with the assurance, just taking it quickly. What was the assurance made in relation to? It was made in relation to the farmland. Of course, there are some issues in the case about which parts of the farm. Was it the whole of the farm or part of the farm? Was he actually really talking about the farming business? At the end of the day, the judge held that it was the farmland held by the father at death. In other words, it was part and parcel of the understanding that, in fact, the father could deal with the farmland as he wanted to during his life, and he would leave what he had at death. There's another interesting part of the judgment, which I think is worth looking at. The family solicitor got involved in giving evidence and gave a witness statement in support, and was cross-examined, that's in support of the claimant, and was cross-examined. And ended up not being able to remember anything about anything, essentially constructing his statement, his witness statement, out of all sorts of various notes that had been made over time on the case file, and was heavily criticised for that because, of course, the standard rubric at the front of the statement had said save where specifically mentioned. I remember all of this. I remember this is all my memory, and of course none of it was. And so the family solicitor was criticised very heavily, and a caution in the preparation of evidence and against construction of hypotheses when delivering evidence. But there were other witnesses who had spoken to the father who were able to support the claimant's case, and he succeeded effectively on establishing his assurance. One of the interesting features of the case is how far detrimental reliance was discussed and considered. And I think in this type of case, and this reflects to some extent the discussion in Guest, there will always be a question of situations where, in fact, the alleged claimant, the claimant, has in fact received a number of benefits, and it's possible to argue that in fact those benefits explain why the claimant behaved in the way that the claimant did. So, for example, in this case, yes, the claimant had lived all of his life and worked all of his life in the farming business, but equally, there was a lot of evidence that he'd always wanted to be a farmer and might not otherwise have been able to be a farmer unless he'd acted in the family business. Point one. Well, lots of other benefits, such as rent-free accommodation, and expenses paid, and a valuable interest in the business. He ended up getting a 95% share in the farming business. That's distinct from the farmland itself, and a pension. And so those had to be. I beg your pardon, I've not put the slide on those. That's on the second part down. Those had to be weighed in the balance. There is some very interesting discussion also about the approach to reliance. The judge distinguished between situations where the father was actually pressurizing the claimant in the case, as opposed to persuading the claimant what to do. And he also drew a distinction between what the claimant was willing to do, simply willing to do because that's what the claimant wanted to do, as opposed to doing something reluctantly. On the facts of the case, both interesting distinctions and matters of focus when one's considering reliance. Reliance is true reliance. There's probably less of a problem with the distinction between you're forced to do something as opposed to persuaded to do something. Forcing someone to do something is not. There's an argument there that it's not really reliance. It's you're being forced, and you were just simply doing it because of the pressure of the situation, as opposed to willingly doing something, as opposed to reluctantly doing something. If you reluctantly do something, there's more of a reliance element there. So the judge distinguished between those, but not those distinctions didn't impact on the facts of this case. And it's very interesting that the judge said, an interesting quote at the bottom, this was, of course, a case where the son had devoted 40 years worth of his life to the farming business. And the judge said it's impossible now to unpick what the claimant might have done differently with his life over 40 years if there had never been such assurances. So, in terms of actual detriment, he had worked incredibly hard, and in particular, he'd foregone opportunities. He declined not to open a truck stop cafe in a nearby motorway. That was a very interesting point because, of course, it was linked to a specific discussion with his father, and it could be shown that the father had said, the judge accepted that the father had said, if you open that truck stop cafe, I'm not going to leave you the property. A very interesting link between the detriment of foregoing this opportunity of his own and the actual assurance, which was that he would be left the property. Was it all in the round unconscionable that the father had not left in the farmland? Yes, it was. And the judge was very happy to reach that conclusion, a very quite clear conclusion. What was the remedy to be? The answer was, perfectly in line with Guest and Guest, that the that the claimant should receive precisely what he'd been promised, namely the farmland itself. But we come to a small interesting feature of this, which is somewhat related to guest, which is, what about the valuable mineral rights under the old quarry land, which was part of the farmland? Should the son, as opposed to his sisters, the remainder of the family members, should the son, because he'd been given the farmland, also be entitled to the valuable mineral rights beneath one of the plots on the farmland? And the answer to that question was given by the judge was no. It was not part of the arrangement or the assurance that the son should obtain the land so that he could unlock any non-agricultural value which the land might have. Now, that's an interesting conclusion, because, of course, it's probably not something that either of them had thought about or were aware of. Nevertheless, the intervention of equity, and this particular plot of land was worth £1.9 million. It was quite substantial in value by comparison with everything else. The intervention of equity required, in that particular case, that in fact he wouldn't get the mineral rights of the land. He would be entitled to the transfer of the farm, excluding the particularly valuable land, and in relation to that, he would be simply entitled to the agricultural value of that land, because that sat foursquare with the promise. So, very interesting reading, that one. The next one is Teesdale and Carter. It's another farming case. This case was a case where a father and mother who were divorcing had a daughter, and during the financial remedy proceedings, the daughter intervened and sought a declaration that a property which was located very near to the main farmhouse, a property that she'd converted, it was an unconverted barn. She said, having spent money and laboured on it, she was entitled to the ownership of that under proprietary estoppel. This was called Cow House, and the name of the property. And this is there are good names for properties, property plots in these cases. In the Spencer case, there was a field called Handkerchief. You either go from the very inventive or the very particular, very familiar and very informal to the very basic cow house. And this particular case, it was a claim for an estoppel for this property, which had been built very near to the main farmhouse. The particular element of detriment in this case was that the daughter claimed to have spent £200,000 in renovating the property. And it was said to have been raised by a mortgage for about £150, and she'd paid the rest of it. An interesting point here. A will made by the father and mother in 2011, that is 2 years after the daughter moved into the converted barn, transferred Cow House to both of the daughters equally. In other words, it didn't reflect what the daughter said was that she was assured that she would be the owner of the property. Now, the judge at first instance ruled in favour of the daughter, and this was an appeal. And the appeal was upheld, the circuit judge, and it upheld his decision that she was entitled to the transfer of Cow House. And I just want to touch on one or two of the grounds of appeal. It's very interesting reading. The first ground of appeal was a general attack on the assessment of the judge's assessment of the witnesses and the evidence in the case. And as we all know, that's an incredibly difficult appeal, appeal point to run. But I just want to mention one aspect of the evidence, which was that the daughter, who had paid £200,000, she said, for the renovations, and indeed was also paying this mortgage of £150,000 that had been taken out, I think, by the father or the father and the mother in relation to the improvement fund. She had paid that back to her father, and the entries in her bank statement said that was rent. That's the word rent was used. And additionally to that, in the father's accountant had also used the word rent in his accounts regarding the repayments back of the mortgage sum. Now, that was really quite an important piece of evidence. In the appeal court, if you look at the quote that I put up on this page, the appeal judge seemed to skirt around this quite easily. He said that he didn't think they were rent because, in fact, the payment started to be made about 9 months before the daughter moved into the property. Well, that's a fair point, but it's not the most sound or conclusive points. So I move on. He said that the payments matched the mortgage instalments and they didn't increase like rental payments. Well, okay. And he said, thirdly, there was no formal tenancy agreement. Well, it was a family. And fourthly, he said the husband said that he was told by his accountant that he had to treat them as rental payments, which is not terribly good justification, I don't think. But nevertheless, the appeal judge held that the judge's treatment of that as not being rent, as in fact payments by the daughter, that was good. There was also another issue about not only the 2011 will, but the 2018 will, which was a new will that was discovered. In the 2018 will, just like the 2011 will, the property was left to the two daughters, not just for the daughter alone. And wrapping things up quickly, and I'm going to bring things to a close now. You do wonder, a bit like Lloyd, if you ever saw Lloyd Grossman in Through the Keyhole, when he used to go into celebrities' houses and he used to sort of go to the camera, these are the clues, and he used to say, what about this clue? What about that clue? And in this particular case, you've got these payments described as rent in the bank statement. And you've also got a couple of wills, not one will, but a couple of wills, leaving the property to the two daughters, not to the single daughter alone. Now, at a certain point in time, the evidence one would have thought might stack up rather against the daughter who did succeed in this case. And one does wonder why the appeal court did find it so easy, as they did, to squash the appeal. And then one finds out that the cow house was actually only worth about £250,000. And the costs involved up to trial were £828,000, and the costs of the appeal were £220,000. And so the legal costs of all this dispute overtopped the actual value of the property concerned 4 times. If the appeal had been successful, there would have had to have been a retrial. And some people might say that this probably added to the problems for the appellant in this particular case. Lastly, I'm not going to go through this in detail. Lastly, just a little point about remedy. The judge himself asked himself what was the minimum equity to do justice in the case. And he was there were 2 competing possibilities: to pay the daughter off, the net equity in the property of £153,000, or to allow the daughter to actually have the property. That is property right in the middle of some farmland and next to the main house, notwithstanding that the parties were now warring parties. Well, the judge followed the guest line and said that the daughter had been promised this. That was what she was going to get. And in those circumstances, she succeeded. Thank you very much for listening. I'm now going to pass you into the very capable hands of Jeremy, and I will take my leave. Thank you very much.
Thanks, Desmond. Hi, everyone. Thanks for coming. As part of our TOLATA case update, I'm going to be looking briefly at 3 decisions. I was just explaining that I'm going to be looking at briefly at 3 decisions. It will be brief. The first 2 concern TOLATA remedies. In other words, where there's no dispute about the extent of beneficial ownership, the debate being about how that's realised or enforced. And one further case, which is just really a good case illustration about how the courts determined a family dispute, about the beneficial ownership of properties within financial remedy proceedings. So the first case we're going to look at is Savage and Savage. It's a Court of Appeal case, the second appeal, concerning the correct interpretation of section 15.3 of TOLATA. And that's the section that sets out which factors a court should take into account in exercising its powers to resolve disputes given to it by section 14. And in particular, where there's a dispute between beneficiaries and how interests are to be realised, whether the court's entitled to take into account the circumstances and wishes of the minority beneficiaries. Well, the factual background of the case is relatively straightforward. As I say, financial remedy proceedings. Raymond, the husband, was 72 years old at the date of the proceedings, and part of the matrimonial property in dispute included his interest in 3 parcels of land on a farm in East Sussex. It was clearly a rather beautiful piece of real estate there. They were held on trusts for Raymond and the 4 children of his late brother, adult children. Raymond had a 2/3 interest in the biggest parcel of land, a 3/4 interest in the second largest, and a 50% interest in the smallest. And his brother's children had held the remaining beneficial interest. Both Raymond and his ex-wife wanted to sell them all as part of the financial settlement. Raymond wanted them sold as a job lot, meaning that all the beneficiaries would receive the net proceeds of sale rather than retain bits of the land itself. But importantly, one of the children, Frank, ran his business from one of the fields, essentially. It was a campsite. I think there was a tennis court and other facilities. And unsurprisingly, he didn't want the bit that he was on to be sold from under him. And he and his siblings argued that Frank should be granted a right of preemption over that bit of the land with his business on it, so he could buy everyone out. There was no agreement, and the issue came before the district judge on a preliminary issue. A valuer gave evidence about how the sale of the properties might be achieved, and he said it was possible to sell all the bits as separate lots, and you'd still get more or less the same price. And the district judge sided with Frank and his siblings, and he even though, of course, collectively they held the minority interest in the 3 parcels of land, and he went on to set out the price that Frank should be entitled to buy his bit of the land from the others for. Now, in his reasoning, the debate really centred on the exercise of the court's jurisdiction under Section 14 of TOLATA, which, as you know, gives the court a wide power to make any order relating to the exercise of the trustee's functions. And of course, that would include the mechanism of realisation of those interests. And you'll be familiar, I've set it out there, that's Section 14, that essentially gives the court the power. And then Section 15, how that power is exercised, the matters to which the court is to have regard, says Section 1, subsection 1, in determining, include, it says, and then sets out a number of very sensible things that the court needs to take into account. And significantly, in subsection 3, the matters which the court is to have regard also include the circumstances and wishes of any beneficiaries of full age and entitled to an interest in possession in property subject to the trust, or in the case of a dispute, of the majority according to the value of their combined interests. The judge decided that he was not prevented by that subsection 3 from having regard to the circumstances and wishes of the siblings as minority beneficiaries. He acknowledged that whilst Frank could use his share of the sale proceeds to buy another plot, it wasn't the same as continuing his campsite where he was, with all of the attendant advantages that are involved. And that he reasoned that whilst he was obliged to take into account those factors in Section 15, it wasn't a straitjacket, and the exercise of his discretion wasn't governed by them alone. And he drew strength in that view from the judgment of Lord Justice Briggs in the case of Begum and Hafiz, a case reported in 2016. And I set out the quote there. A non-exhaustive list. He categorised the features set out in Section 15. Well, Raymond, the husband in the Financial Remedies proceedings, appealed to the circuit judge, and he considered whether the district judge had misdirected himself as to the meaning and limitations of Section 15.3 particularly, and he found he had. He decided, His Honour Judge Farquhar decided, because there was a dispute between the beneficiaries, subsection 3 prevented the court from having any regard to the circumstances and wishes of the siblings, being the minority interest. And he decided that really the only wishes and circumstances he could take into account were Raymond's. And he justified that on a strict interpretation of subsection 3. The wording, he said, of that particular subsection can only make grammatical sense if the court can only take one of the considerations into account. So he set aside the order for the sale without giving poor old Frank any right of preemption. And so on, as things stood at that point, the whole lot was going to get sold. Well, Frank appealed to the Court of Appeal, and the appeal was allowed. They restored the district judge's decision. The reasoning, I mean, the judgment centres very much on the correct interpretation of the words of the statute, unsurprisingly, really. Lord Justice Snowden noting that the words and the passages in the statute derive their meaning from their context, including the section of the statute and statute as a whole. The opening words of section 15.1, after all, included the words, the matters which the court is to have regard in determining the application for an order include, and the ordinary and natural meaning of those words did not, in the Court of Appeal's view, create a set closed list of factors which the judge should consider. And also in section 15.3, that subsection uses the word include and have regard to, noting that the subsection does not say to the exclusion of any others. The Court of Appeal also cited the Law Commission's working paper and subsequent 1989 report, which preceded the introduction of section 15 and, forgive me, 14 and 15 of TOLATA. And there they are. It was very much comments along the same lines. It doesn't give certain interests form priority over certain others. They're simply designed to indicate, said the Law Commission, some of the more important factors to which the court should have regard. So there we are. The Court of Appeal held that the second judge had misinterpreted the meaning of section 15.3, misapplied it to the facts, and that the district judge was essentially right in including the wishes of the minority beneficiaries and working out what was the correct outcome. Well, what can we derive from this, apart from stating to the obvious? I mean, obviously, the judges aren't hidebound by the factors in section 15. There's no established rule or suggestion that some sort of special or exceptional circumstance needs to be shown before the majority beneficiaries' views are overruled. And the relative weight of the factors are entirely within the judge's discretion, and he can go outside section 15 if he thinks the circumstances and facts merit it. This decision has attracted some comment since the publication. It is enough importance being accorded to the majority beneficial interest. It might have been argued by Raymond. It's not clear that it was. It may have been, but even if the minority beneficiaries' view can be taken into account, shouldn't the majority beneficiaries' view be accorded more or particular significance? The wording, I mean, the way I read section 15.3, it seems to me that there's quite a good argument that it should. But on the decision, a straight reading of the decision in this case, it's, the considerations are laid out in a pretty level way. Okay, the next case I'm going to look at quickly, I can take this fairly quickly, is Al-Duki and Abdullah. It's from last year, in fact, this case. It's a sort of remedies case. Again, there was no dispute about the beneficial interests. It was a case brought for remedies, including damages for breach of an order that was made by Mr. Justice Moore in proceedings under the Matrimonial and Family Proceedings Act 84 and TOLATA, although the parties had in fact been married. So I'm going to refer to them as wife and husband. In 2021, Mr. Justice Moore made orders in respect of 3 properties held by the parties as joint tenants pursuant to an express declaration of trust. He determined that all 3 properties should be sold and the proceeds divided equally. it was noted that at the time by the judge that on the market appraisals, this would give the parties about just under £2 million each on the net proceeds. I've set out the market appraisals there. At 2.25 for one, between 2.25 and 2.5 million for another, and 4.5 for another, that they were all subject to mortgages. The wife claimed that subsequent to the order, the husband hadn't subsequently paid the mortgage or the service charges, and had generally sort of mucked about. In fact, the mortgage company, USB, issued demand letters in relation to two of the properties, the Piazza and Craven Street, and much lower offers, I say much lower offers were accepted on the Piazza and for Craven Street. And in relation to Albion Gate, the wife complained that the husband had put tenants into the property without her say-so. After the order was made, she claimed they obstructed the viewings. The husband sort of didn't clear up the rubbish that was left around in the property. You know, the sort of complaints that we do sometimes see once the main issue's been resolved, and there's a sort of, you know, ill compliance with getting on with it and selling and realising the assets. So it's quite a good little illustration of what happens when that happens. Interestingly, by the time of the hearing of the wife's sort of enforcement / damages action, an offer had been made for Albion Gate for 2.4 million. So in other words, for a bit more than was envisaged at the original hearing. And the husband claimed this was as a result of him being clever in sort of encouraging a bidding war on that property. The wife sought financial recompense, which would provide her with the original 1.9 million, which the court said she would receive in the original trial. And she was essentially asking for that figure rather than a strict division of the proceeds as provided for in the original order, is the way in which I read the decision. And she asserted, unsurprisingly, that the husband alone should bear the costs of the receivers and other associated costs. The husband denied the claim, arguing the eventual sale price will often vary from the estimated value at trial, and that the wife would hardly have complained had all the values gone up. Well, Mr. Justice Moore, he dealt with the original hearing, and he dealt with this the subsequent hearing. He determined that in respect of the Piazza and Craven Street, that the husband hadn't, in fact, obstructed the sale. And in any event, I suppose this is the important bit, the difference between the sale price, the offer price, now, and the marketing appraisal that was before him at the original hearing, was only about 5%, well within the tolerances of the sort of the property market. He decided, again unsurprisingly, that the extra costs associated with non-payment of the mortgages and the receivership, it was hundreds of thousands of pounds, the receivership costs, were as a result of the husband's unilateral actions, and he should bear those sums. And in relation to Albion Gate, whilst the husband had caused delay and installed tenants unilaterally, and obviously those shouldn't have done those, is the implication, there was no loss because the property sold for more than the initial market appraisal. Again, it doesn't establish any principle really, this case, but it's a good illustration of how a court might deal with a sort of squabble about how parties behave after an order for sale and a division has been made, and that the uncertainties of the property market need to be factored in to any appraisal of one's client's claim that the other side has caused problems with the process of marketing and sale. Okay, the last case we're going to quickly look at is AW and RH. A case decided this year, it's first instance decision at county court level. Forgive me, it's dealt with in a family court because a family court with county court jurisdiction, because it was a Financial Remedies case, and that the issues were dealt with as a preliminary hearing, as of course we're all used to. It was in relation to a dispute about the extent of third-party rights of two interveners in financial remedy proceedings. And again, a bit like the last case, it's just a good illustration of what a court has done given a set of circumstances, and that's always interesting to have a look at, isn't it? When we're trying to advise clients, it's always good to see if there are any sort of echoes in previous decided cases. It was interesting for a number of reasons, but perhaps particularly because it's a good example of family members having a history of helping each other, so essentially being philanthropic in their property acquisitions and dealings, really as a matter of good habit and intentions, but without the necessary intention that help would lead to the acquisition of beneficial interests. Again, that's something that I suspect we've all seen in practice. The interveners were the husband's siblings, his brother and sister. The husband actually lacked capacity at the time of trial and acted via the OS. He didn't give evidence. The OS had filed a position statement which supported the interveners, and in particular what they were saying about the extent of their interests in the properties. I'm going to refer to the property. There were two residential properties, conveniently called number 11 and number 22. Number 11 was bought by the husband and his brother some time ago, 1983. They were registered as legal owners. There was no declaration of beneficial interest or statement or anything in writing, other than the fact that it was conveyed in joint names. But the brother asserted that he had paid for it entirely, and that the purpose of it being conveyed into joint names was to avail themselves of the double taxation benefits of Maris, if you remember those halcyon days. Number 22 was bought a couple of years later by the husband in his sole name, but his brother helped him out with the deposit and other associated costs, but the brother didn't claim any interest in it for the purposes of the financial remedies proceedings. The husband and wife married in 2005, and in 2009, it was necessary to raise a mortgage on number 22, remembering that was the property in the husband's sole name, to help settle a claim brought against a property belonging to the husband and his siblings' mother. So they were doing something to help her out. To do this, the sister was joined on the title documents as legal owner. And again, there was no declaration of beneficial interest at that point. The husband and wife, they had two children by this stage, moved into number 22 in 2014. Until that point, tenants had been paying rent and occupied the property, and the rent covered its costs. In fact, when the husband and wife family moved in, some lodgers remained there paying rent. It doesn't add too much to the debate, that bit. But importantly, at about the same time, the husband's name was removed from number 11, which, if you remember, was the property bought by his brother, in relation to which the husband had made no financial contribution. What the wife claimed in relation to number 22 was that she'd made substantial contributions by funding improvements. And she also claimed that the husband had an interest in number 11. And she denied, of course, that the sister, when she went onto the title of number 22 to assist in buying out the claim against their mother's property, she denied the sister had any interest because of that. The wife's recollection on certain issues was hazy. She wasn't a direct witness to some of the important things being asserted by the interveners. The sister importantly accepted that number 22 had been owned by the husband for 24 years before she was added to the title. And she said she only wanted to be a legal owner to give her protection as she was liable under the remortgage. And she agreed she hadn't otherwise made any other contribution. The wife argued that the husband had beneficial interest to number 11, despite making no contribution except enabling the Maris relief. He was named, she argued, on the title at point of acquisition back in the 80s, and that this pointed to beneficial entitlement, and that she said that the later change in legal ownership was merely to distance himself from this valuable interest. The judge noted the irony in the argument that the addition of the sister to the legal title to number 22 without financial contribution shouldn't affect beneficial interest. In other words, that the sister got nothing because she went on the title, but almost in the same breath arguing that the husband, for almost exactly the same reasons, had a half interest in number 11, his brother's property. The judge also observed that this was a family which provided significant amounts of mutual support to each other. The husband's brother gave him support when he bought his property. The husband gave his brother support with respect to the Maris tax benefits. The sister helped the brother in obtaining a charge on his property, and the husband and his siblings assisted their mother when litigation was ongoing. And of course, this was all to their credit, but the judge sort of rather forlornly said that it made the assessment of the historic intentions quite complicated. But she found, unsurprisingly, that there was no doubt until 2009 that the husband owned number 22, and that other than the tax benefits, the husband had contributed nothing to number 11. She decided that the husband had no beneficial interest in number 11. The wife couldn't rebut the brother's account of why the property was acquired, and it was unclear why the husband would therefore have a beneficial interest. That probably comes as no surprise to any of you. And it was totally inconsistent for the husband to obtain a 50% beneficial interest for simply providing a tax benefit. And that the change to the title in 2013, you remember that's when the husband came off the title, and of course it coincided with difficulties in the marriage. We'll all be used to that sort of thing happening. That simply regularized the reality of the beneficial interest, even if the husband was being removed to protect the title and any claim by the wife. This could just as easily have been done from a fear of an unjustified claim than a justified one. And in relation to number 22, the judge found, consistent with the previous decision about number 11, that the sister had no beneficial interest. Although, of course, she started from the position that the beneficial interest follows legal interests on the evidence of the parties' intentions. The judge concluded that the sister didn't intend to have any beneficial interest in number 22 when she was added to legal title. But perhaps an unsurprising decision, but an interesting one to read and to see how the judge has wrestled with sort of charitable intentions and helpful actions by members of a family being painted in a different light many years down the line, and how one sorts out, looking very carefully at the evidence, particularly the oral evidence it comes across in the decision, sorting out what those intentions actually were and comparing them with the actions on the ground. Thank you very much. That's all I'm going to be saying. I see that we're 6 o'clock now, which is slightly beyond what the timing that we were planning for. Thanks so much for attending. If there are questions, I can't see on the screen if there are, but there are. We're very, very happy to follow those up by email. If you're watching the recording or watching me live or the recording, please email them through to events@42br.com. The recording will be available shortly. We'd be grateful for any feedback, of course. And the next and final webinar in this series is this Thursday, in fact, and will be the postponed session by Gemma Taylor, KC, and Anne Osborne. And the title of their talk is Disclosure, an Absolute Duty or Not? ? So I'm sure you're all feverishly looking forward to that. But in the meantime, have a lovely evening, and thanks so much for coming.